Let's talk about the transfer and death deed. So in 2016, the state of California enacted another way for homeowners to avoid their real estate going into probate when they pass away. The first way is to put your property into a trust. The trust is going to state exactly what's to happen when you do pass away, so that will avoid any squabbling that may happen amongst the heirs. So now let's talk about the transfer and death deed. Why do people do it? If you don't have a lot of assets, this is really good for some simple estate planning. Another thing that makes it attractive is you don't have to have anybody on title with you. They get the property when you do pass away. So let's go over a few important rules that you need to remember if you decide to go down this route. So number one, the transfer and death deed does need to be notarized, but it also needs 2 additional witnesses. The deed must be recorded within 60 days of you executing the deed, meaning you signing it. Upon death, the beneficiaries must serve notice to all the transferor's heirs with the transfer and death deed and the death certificate. Number 3, the beneficiaries must record an affidavit of death of transfer under revocable transfer on death deed. That'll essentially put it in the beneficiary's name. Number 4, and this is the important one, the beneficiary cannot sell this property for at least 120 days. So it's important that you get that affidavit death of transfer recorded as soon as possible so you can start that timeline. Keep that in mind. Hopefully you guys found this information useful. And remember, on all your real estate transactions, choose Mike and Bobby with Chicago Title.